Welcome, everyone, and thank you for joining Sutherland's latest insurance litigation webinar. We started this monthly series in October 2014, and we are resuming this month after a summer break. My name is Tom Curvin, and I'm joined today by my Sutherland colleagues Tom Byrne, Sean Jordan, Valerie Sanders, and Stacey Mohr. Today's webinar focuses on cases in the United States Supreme Court that should be of interest to the insurance industry. Now, we will start with a brief review of the Supreme Court term that just concluded in June of this year. That term saw significant decisions with implications for insurers on topics including disparate impact discrimination under the Federal Fair Housing Act, which does apply to certain types of insurance, same-sex marriage, ERISA fiduciary duties, and federal class action and removal procedure. After touching on those cases, we will shift gears to review the upcoming Supreme Court term. The new term kicks off with a conference of the justices next week and oral argument the first Monday in October. Already on the docket for this term are merits cases involving ERISA fiduciary duties, ERISA preemption of state laws, class action standing, and class action certification procedures. Now, if you'd like to receive CLE credit for this webinar, please download the CLE sign-in sheet that's on your viewing console and follow the instructions there. If you have any questions during the webinar, please submit them via the Ask a Question text box on your viewing console. So let's start by reviewing some of the highlights of the prior year's Supreme Court term, starting with a Federal Fair Housing Act case out of Texas. And my colleague Sean Jordan is going to address that case. Sean?
Thanks, Tom. The case is Texas Department of Housing and Community Affairs versus the Inclusive Communities Project. And as Tom noted, this is a 5-4 decision from the Supreme Court that endorsed disparate impact liability under the Fair Housing Act. Now, as you're all probably aware, the Fair Housing Act broadly prohibits discrimination in real estate transactions. And the importance of the case is that in contrast to a disparate treatment case where a plaintiff must establish that the defendant had a discriminatory intent or motive, a plaintiff bringing a disparate impact claim can challenge practices that have a disproportionately adverse effect on minorities regardless of intent or motive. The court answered the question in the case of whether or not you could make a disparate impact claim under the FHA in the affirmative, saying that such claims can be made. And in doing so, the court looked to its cases interpreting two other civil rights statutes, Title VII of the Civil Rights Act of 1964 and the Age Discrimination in Employment Act. It said those cases provided essential background and instruction. The court noted that Congress' use of the phrase otherwise make unavailable in the Federal Housing Act was similar to the phrase otherwise adversely affect that is found in Title VII and the ADA, and said in all of these cases that language indicates that the statute and what Congress's intent was to also prohibit practices that have an adverse effect regardless of intent. Now, importantly, although the court authorized disparate impact claims, it also put some significant limitations on those. To begin with, the court emphasized that lower courts must, quote-unquote, examine with care disparate impact claims at the pleading stage. And that decision, in that way, the decision empowers lower courts to dismiss claims at an early stage and without subjecting defendants to expensive and often intrusive fact discovery. The court also said that it's not enough for a plaintiff to show just a racial imbalance or just a statistical disparity. Rather, plaintiffs must establish a, quote-unquote, robust causal link to the defendant's actual policies in order to make a prima facie case. The court also held that the defendant's justification defense will not be contrary to disparate impact unless it is artificial, arbitrary, and unnecessary. So, importantly, the court empowered defendants with this justification defense. I think Tom's going to talk about the impact of this decision for insurers.
This case was watched closely, particularly by the property and casualty side of the industry, because the Federal Fair Housing Act, through regulation, through HUD regulations and through case law, has been interpreted to apply to the sale of certain types of insurance that are sold in connection with home buying and home rentals. In particular, it's clear under the FHA that homeowners insurance, the underwriting and sale of homeowners insurance, is subject to the requirements of the Federal Fair Housing Act. Some courts have held that the sale of renters insurance may also implicate the Federal Fair Housing Act, and some courts have held that the sale of mortgage insurance also is subject to the Fair Housing Act. And so for those types of insurance, this case suggests that there could be new theories of liability, more expanded theories of liability for challenging the sale of these types of insurance. Disparate impact claims are problematic because, as Sean mentioned, they can have the effect of shifting the burden to the insurance company defendants to justify underwriting practices, for example, and that may require inquiry into underwriting decisions and underwriting records that companies would probably rather not have to litigate. This decision may also encourage more robust enforcement of similar state law anti-discrimination practices by state law regulators, insurance commissioners, and attorneys general. So we'll have to see how that plays out. All the major property and casualty trade associations participated in this case as amicus parties. Unfortunately, the industry's positions did not prevail, and so we'll have to see what further impacts this case is likely to have for the PNC side of the business. Surely the most noteworthy of cases decided this term were the 3 same-sex marriages cases, and Stacey Mohr is going to tell us, briefly summarize those cases for us and mention some implications that they have for insurance.
Thanks, Tom. Obviously, everyone is well aware of the same-sex marriage cases that were decided last term. Again, the 14th Amendment requires a state to license a marriage between 2 people of the same sex, and the court also held that it requires a state to recognize a marriage between 2 people of the same sex when the marriage was lawfully licensed and performed in another state. Prior to the decisions coming out back in the spring, we flagged in an earlier webinar some of the possible implications of a possible ruling on those cases. So we won't belabor that now. Some of those dealt with effect on state anti-discrimination laws, and particularly the effect of marital status in underwriting and the correlation to risk or mortality in underwriting decisions. So for auto insurance and on homeowners insurance, some insurers currently offer discounts to married drivers or married homeowners, and those insurers may be pushed to include same-sex married couples in that same risk group for underwriting purposes. And as to annuities, and the current data does support links between marriage and mortality, and that's allowed the use of marital status as a factor in annuities underwriting and withstanding challenges to that. But there's currently no data available for same-sex marriages, and to complicate things more, civil unions or domestic partnerships. So those could also raise legal issues relating to anti-discrimination laws, about how that same-sex marriage status might affect underwriting decisions. And none of this so far has, we haven't seen a lot of litigation on these fronts. We would expect that the first instance of this would be addressed by the regulators.
There was also an ERISA case decided by the court this previous term dealing with ERISA fiduciary duties. Valerie, will you speak to that, please?
Thanks, Tom. The case is Tribble versus Edison International, which came up through the Ninth Circuit and resulted in a unanimous decision, fairly short decision, authored by Justice Breyer. The case is interesting because it began its life looking more like a limitations case, and by the end, when we see the Supreme Court's opinion, it really has more to do with the substantive scope of the fiduciary's duty of prudence. The issue in the case, the challenge was that that the plan fiduciaries had added to a plan menu some mutual funds from a higher-priced retail class when essentially the same investment was available at an otherwise identical but lower-priced investment class rate. That was alleged to have been an imprudent decision. There were a few different mutual funds at issue. Some of them had been added to the menu within the six-year period of limitations. Others had not. They'd been added back before more than 6 years before the claim was brought. And the question was whether these plaintiffs could complain about those investments which had been added to the menu more than 6 years before they brought their claim. In the district court and in the Ninth Circuit said no, that they couldn't. They found those claims to be time barred. The Ninth Circuit, as you can see from the quote here, construed it mainly as an issue of whether there could be a continuing violation claim. The Ninth Circuit said that there could not. And they acknowledged, as had the district court, and this is the third bullet point there, that if there had been changed circumstances during the 6 years that would prompt the need for a, quote, full diligence review of the existing investment, that maybe would be a new breach, but that evidence didn't exist in this case, so those claims, according to the Ninth Circuit, were time barred. The Supreme Court disagreed, and what we see in the Supreme Court's decision is really another way of looking at the question, not so much in terms of the cognizability of a continuing violation, but rather what's the breach that's alleged to have happened within the limitations period. We see here that this quote says it all. In short, under trust law, a fiduciary normally has a continuing duty of some kind to monitor investments and remove imprudent ones. And so according to the court, the Ninth Circuit should not simply have looked at the date the investment was originally made and found the claims to be time barred. So it's not so much whether there's a continuing violation, it's a matter of a continuing duty. And the takeaway here really is that the status quo may be actionable later on, depending on whether, under trust law, and this case has now been remanded to the Ninth Circuit for specific consideration, the status quo may be actionable if there should have been a review, a removal, a change, and there was not. So we'll see how that plays out on remand.
And then the final case we wanted to review from this term involved federal class action and removal procedures. And Tom Byrne is going to tell us about the Dart Cherokee Basin case.
Usually removal is a defense-friendly maneuver, of course, for financial services defendants. In the Dart case, the court relieved decades of uncertainty about what must be attached or provided with a removal notice when it held that only a short and plain statement of a plausible allegation of grounds for diversity jurisdiction is required. That short, plain statement language is borrowed from the civil rule, and the plausible allegation standard is familiar from those who have followed developments in the motion to dismiss area with the well-noted Iqbal and Twombly cases that set forth that plausibility standard. So the jurisdictional allegations must be plausible in light of the pleadings attached, but no evidence or affidavits need to be provided or filed with the removal notice any longer. That uncertainty had prevailed for years in the lower courts because of limited appellate review of remand decisions, but the court now has definitively ended that controversy, and that should be a welcome development. A few points about DART. The court also held that in Class Action Fairness Act cases, there is no presumption against removal, which had been language that had found its way into a number of lower court decisions. The court did not go on to hold that there never is a presumption against removal that would be applicable in other non-CAFA cases. The court reserved that question for another day. The court also specified that when there is a challenge to a jurisdictional amount allegation, that the challenge is to be resolved by the district court by a preponderance of the evidence standard. So the court, hoping, I think, to put this issue to rest forever, has set out a pretty reasonable and easy-to-follow roadmap for what should happen with respect to a jurisdictional controversy in a district court.
All right, let's shift gears now and look forward to the upcoming term of the Supreme Court, and Tom Byrne is going to give us a lay of the land.
Exciting time of year, Tom. For the first Monday in October, the court has already accepted 34 cases for argument for this upcoming term, and that means that they have roughly 35 or so slots available. The court decided 68 argued cases last term, which has been consistent with its workload for the last few years. At one point in time, the court, of course, would accept about 120 cases for argument, but those are from bygone days, although several of the justices have talked about perhaps taking more cases. The pattern in recent years has been around 70. So roughly 10,000 cert petitions are filed annually, and the big log jam is at the upcoming Long Conference, which is next Monday, where a couple of thousand cert petitions at least will be resolved, and the court will, and you often hope strategically that your petition is not among them, because your odds, according to the conventional wisdom, are lower when you are stuck in that log jam rather than coming up later in the year. So strategically, there are ways to slow down your petition if you believe that conventional wisdom. But we'll find out on Monday which cases will join the rest that have been accepted. The court won't fill up its docket by any means. It may only take 4 to 6 additional cases and see how the year develops. The first argument will be held on the first Monday in October, a week later.
So already on the docket, cases where the court has already granted review on the merits and put on the docket are several that we want to discuss briefly today with implications for the insurance industry. And the first one is an ERISA. The first two we'll talk about are an ERISA case. The first one is Montanil versus Board of Trustees. This is a case out of the 11th Circuit that's up before the Supreme Court. And the issue here is the trustees' right to sue to enforce terms of the plan. This case involved an ERISA employee health plan. There was an employee who was covered under the plan was injured in an automobile accident. The plan paid for $121,000 in medical bills, and then the injured employee then recovered from the at-fault driver in a tort case, recovered about $500,000. The ERISA plan at issue here, like many ERISA plans, had a reimbursement clause that provided that the plan has a right to reimbursement out of any recovery, and the plan administrator tried to enforce that reimbursement right by demanding reimbursement of the $121,000 in benefits that had been paid, but the employee, through counsel, refused to pay, and so the trustee, the plan administrator, then filed a lawsuit to try to recoup the money. And the issue was whether or not the trustee had an equitable right to recover that money when the employee defended the case by saying, basically, I've already spent the money, I don't have it. Under ERISA, plan fiduciaries have the right to pursue equitable remedies to enforce the terms of the plan, but what they don't have the right to do is typically sue for money damages. And so the issue in this case was whether they could enforce, whether there was money available that they could point to, that they could, in effect, ask for an equitable order attaching it or a lien on it where the money had actually been spent. This issue may seem somewhat arcane, but in fact, according to industry groups, ERISA plans recover in excess of $1 billion annually via reimbursement by the reimbursement clauses. There's actually a split in authority in the lower courts. Most courts hold that where the employee did in fact have the money at one point in time, it's appropriate for the fiduciary to try the fiduciary has the right to pursue equitable relief to try to get the money back. But a couple of other courts have actually held that no, where the money is no longer in the possession of the employee, the plan fiduciary is basically out of luck and can't sue to recover it. You find these reimbursement clauses in many different types of insurance policies, property and casualty policies, in addition to many health insurance policies that are outside the ambit of ERISA. It will be interesting to see how the court decides the case. The court could decide the case on very narrow ERISA grounds, but it also could decide the case on broader grounds that may have some applicability beyond even ERISA-covered plans, so we'll be watching that one. The next case we wanted to discuss is the Go Beal case, and this case involved preemption of state medical records reporting requirements. Stacey, tell us about that one.
Sure. As Tom said, this case involves an ERISA self-insured employee health plan that Liberty Mutual administered, and they used a third-party administrator, Blue Cross Blue Shield. And the Vermont statute issue and regulations under the statute requires insurers to file in a statewide medical records database various information, including medical claims data, pharmacy claims data, and member eligibility data, which obviously would include a lot of sensitive information. And as background, a lot of states have similar statutes and regulations with the purpose of improving the quality and utilization and cost of health care in their states. And at this point, 16 states have some type of healthcare data collection and healthcare databases, healthcare claims databases, rather. They all have various requirements for what type of data must be submitted. Some require mandated reporting, some require voluntary reporting. The Vermont statute had various levels depending on the size of the plan. Some were mandatory and some were voluntary. And some actually exclude self-insured employee plan data from the reporting requirements, although the majority, like Vermont, require such plans to report claims data. So that's sort of the overlap here with ERISA. And one of the states actually that has such plans or requirements rather has had a data breach of the database. So it's obviously a concern of having to report this sensitive information to these databases, and also the different burdens throughout different states and different requirements. So the Second Circuit ruled that ERISA preempts the Vermont statute and regulations and does not require that Liberty Mutual and their third-party administrator provide the information to the Vermont authority. The holding of the Second Circuit was that the reporting, because reporting is a core function of ERISA, and that it's shielded from potentially inconsistent and burdensome state regulations. And there was a dissent in the case that essentially argued that the reporting requirement imposed by the Vermont statute differs from the reporting that is required by ERISA and wasn't the kind of state law that Congress intended to preempt by ERISA. And also that Liberty Mutual had failed to show that there was any actual burden, much less a burden that would trigger ERISA preemption. And that essentially that the statute does not interfere with an ERISA plan's administration of benefits, which was really the core function of ERISA. And interestingly, the United States has filed an amicus brief on behalf of the respondent in this case, or against the petition being granted, and arguing that ERISA is, that the state statute is not preempted by ERISA. And again, the argument there is that they serve different purposes. The database statutes and ERISA serve different purposes. ERISA governing the design and implementation of employee benefit plans, where again the database statutes are concerned with improving the quality and cost of health care in states and have nothing to do with the claims payment process, which is what ERISA is concerned with. And they were They also point out in their brief that the Vermont reporting requirements don't impose binding obligations with respect to any core matter of plan administration, such as the vesting of benefits and the designation of beneficiaries. So there are some interesting preemption arguments there, and we'll see how that comes out this term.
All right, why don't we shift gears a little bit from the ERISA area to some procedural issues, including who has standing to sue, and then some class action issues. And in particular, the first case on class action procedure, Campbell Ewald versus Gomez. Sean, tell us about the Campbell case.
Sure. The Campbell Ewald Company versus Gomez case is one of a number of very interesting class action cases on the court's docket this term that we'll be talking about. The Campbell Ewald case raises two very intriguing issues. The first is whether a case becomes moot and therefore beyond the judicial power of the courts under Article 3 when the plaintiff receives an offer of complete relief on his claim under Federal Rule of Civil Procedure 68. And then relatedly, whether the answer to that question is any different when the plaintiff has asserted a class claim under Federal Rule of Civil Procedure 23, but receives such an offer of complete relief before any class is certified. Now, these issues arise in an interesting factual context. This is a case that involves the Telephone Consumer Protection Act. Campbell Ewald is a national marketing company that sent text messages on behalf of the U.S. Navy to recruit new sailors. The plaintiff is someone who received one of those text messages and says that he did not want to receive it. The TCPA, the Telephone Consumer Protection Act, provides for statutory violations for unauthorized messages. The penalty can be up to $500 for each violation, and that can actually be tripled if it's a willful violation. So although an individual's claim may not be particularly significant, when these are roped into a class, they become very, very significant. In this case, the plaintiff's claim was on behalf of a nationwide class seeking literally hundreds of millions of dollars. Now, before this class was certified, indeed before the plaintiff had even moved for certification, the defendant here offered complete relief to this plaintiff. In fact, Campbell Ewald offered the plaintiff, number one, the equivalent of more than treble damages, over $1,500 for the one text he got. It also agreed to additional relief for any reasonable costs he incurred and agreed to enter an injunction not to do it again. This was all offered under Federal Rule 68 and was seen as complete relief for the claim made by this plaintiff. Now, what the plaintiff did was the plaintiff refused to accept the offer, moved to strike the offer, and then moved to have a class certified. The district court held that the plaintiff's claim was not mooted. I should say that the Campbell Ewald argued that its offer mooted the plaintiff's claim such that he could not represent a class. The district court disagreed and said that it did not moot his class claim. However, there was a sovereign immunity issue in the case, and the court dismissed it on that basis. The appeals went up to the Ninth Circuit. The Ninth Circuit determined, as did the district court on our key procedural issue, that again, the offer under Rule 68 of complete relief did not moot the plaintiff's claim and likewise did not moot his ability to represent a class. So, interestingly, the Ninth Circuit decision and Campbell Ewald's claims all circle around a Supreme Court case from a couple of terms ago. And that is, which you may recall, the Genesis Healthcare Court versus Simzik case. You can find this case at 133 Supreme Court Reporter 1523. In that case, which was issued in 2013, the court held in a related collective action case under the Fair Labor Standards Act that an unaccepted offer of full relief mooted a collective action. In this case, I'm going to call it the Simzik case, the court held that under a, quote, straightforward application of well-settled mootness principles, unquote, a collective FLSA action becomes moot when the plaintiff's individual claim becomes moot because the plaintiff lacks any personal interest in representing others in the action. Now, Campbell Ewald, in its briefing filed in the U.S. Supreme Court, is, needless to say, relying heavily on the Simzik decision. and saying what holds true in an FLSA collective action should hold equally true for a proposed Rule 23 class action. And the Campbell-Ewald is further contending that under the well-established principle that we all know that a class has no independent legal status whatsoever until it's been certified, that this case is mooted on both counts. It's mooted for the individual plaintiff, and because it was mooted before a motion for class certification had even been filed, this individual couldn't possibly represent a class. Notably, the Ninth Circuit, in its decision, relied on the dissenting opinion in the Genesis case, or the Simzik case, which was a vigorous dissent from Justice Kagan, joined by 3 other justices, saying that an offer of full relief under Rule 68 should not have mooted an FLSA collective action. And I think we can presume that both Justice Kagan and those other justices will likely be of the same mind with regard to Rule 23. So it sets up some very interesting issues. And as we note on this slide, the United States has also weighed in. The United States has filed an amicus brief and hewing to the position the United States itself took in the Simzik case, where it said that an offer of full relief under Rule 68 could not moot an individual's claim in the FLSA context. It's also saying that in this context of a Rule 23 class action, an offer of full relief, number one, can't moot the individual's claim, and number two, also can't make it inappropriate for that person to represent a class. And so the United States has weighed in both of these cases in favor of allowing the individual to proceed. So this case raises very interesting issues on the intersection of the court's standing jurisprudence and its class action procedure jurisprudence. Another case that raises those issues that Tom is going to talk about, very interesting case, is the Spokio case, which also raises very interesting Article 3 issues.
Spokio against Robbins, another Ninth Circuit case. Not surprising, the Ninth Circuit keeps the Supreme Court busy every term. The case has to do with Article 3 standing under consumer protection laws. The case has attracted a heavy barrage of amicus briefs from both sides, and the United States has weighed in on behalf of the plaintiff. And the stakes are high. The question of statutory damages and when they are available has implications that come up under many statutes in the federal system. What's the case about? Well, Spokio runs a people search style website from which you can obtain a lot of information about individuals. Robbins, the plaintiff, was an unemployed user of the site, and he alleged that the site provided inaccurate information about him. Now, the oddity is that the false information that was actually provided was favorable to him, at least in the thinking of most people. Though he was unemployed and single, it described him as having a graduate degree and being wealthy and married, all of which was untrue. The misinformation, nevertheless, he alleged, caused him to experience anxiety and stress and lose money as a result because his employment prospects were harmed also. So the district court, after wavering a good bit, ultimately decided to dismiss the case for lack of Article 3 standing. The Ninth Circuit reversed. The Ninth Circuit held that it was sufficient to confer standing if the plaintiff alleged that his statutory rights were violated, and that's what he alleged. The court reasoned that just providing inaccurate information was alleged a violation of the Fair Credit Reporting Act and was enough to confer Article 3 standing. The issue that the Supreme Court has taken up will be whether or not, or what are the limits, I should say, on Congress's ability to create standing by statute. It's often described as injury in law versus injury in fact. Adding to the intrigue here is the fact that the court took this issue in 2012 in another case. The case was First American against Edwards, and it was fully argued. The issue there was standing under the Real Estate Settlement Procedures Act in a case involving title insurance. And after argument, the court decided that cert had been improvidently granted and dismissed the case without explanation. Certainly a deflating event if you're one of the lawyers who argued for either side. It does suggest that the court was fractured on how to decide the case, And so we'll see if they make any headway in Spokio. Now, there are many statutes with statutory damage provisions, like the Fair Credit Reporting Act. There's ERISA, of course, the Equal Credit Opportunity Act, Fair Housing Act, Fair Debt Collection Practices Act, TCPA, and you can go on and on. So a lot of implications here. And a decision requiring injury in fact would eliminate some class representatives in would-be class actions. It could also mean that class members with no injury would have to be excluded from any class somehow. This is actually also the subject of a pending bill in the House, which is the Fairness in Class Action Litigation Act, H.R. 1927, which has been reported out of committee and is before the full House awaiting a vote. That happened in June. That statute would require that no federal court certify a class unless the proponent of the class affirmatively demonstrates through admissible proof that each proposed class member suffered an injury of the same type and extent as the injury of the named class representative. So the issue is before Congress as well as coming before the court. The focus of many of the industry side amicus brief is on the injury in law argument and the limits on Congress's ability to create standing. It could be that we will receive a fairly narrow opinion here at the end of the day that focuses on the Fair Credit Reporting Act and on the plaintiff's allegations and tries to keep the ruling as narrow as possible because of the potential implications of a broader ruling. Robbins could end up having standing for some of his alleged violations of FCRA, but not others. He does allege that there was inaccurate information published about him. He also makes a number of claims about other violations of the statute for which his standing seems quite doubtful, such as proper administration of the website, proper use of a toll-free number by a credit reporting agency, and so forth, where the government concedes that he wouldn't have standing. But the government analogizes the use of inaccurate information to the common law tort of defamation and attempts to align it with the common law in that respect. So the case will be argued on November 2nd. No telling when we'll have an opinion from the court. It could be one that takes a long time to be resolved because of different views.
Thanks, Tom. Well, there's another significant class action case on the docket this fall. This one involves Tyson Foods and issues that go to class certification standards. Valerie, tell us about that one.
Thanks, Tom. So this case, Tyson Foods case, has come up through the 8th Circuit. It originated in district court in Iowa. The claims are by workers at a Tyson pork processing plant, a single plant in Iowa, that they were not properly compensated for overtime work in violation of the Fair Labor Standards Act and also Iowa's wage and hour laws. The claim is essentially that while Tyson had a system for capturing time taken to don and doff and clean the equipment used for various jobs in the processing plant, the claim is that that system was not fully and completely capturing that time such that employees were being undercompensated and overtime was not being paid when proper calculations, they allege, would have brought some employees, and that some may turn out to be critical, over the 40 hours per week mark. Tyson pointed out, and I should say, this originally came up through the district court before Walmart v. Dukes was decided. It first came up through the district court. This claim was made. Tyson pointed out, look, these folks are in two very different areas of the plant. There are more than 400 distinct jobs involved in the putative class. There's all kinds of different equipment, including some, I guess, was not required. There was some personal choice involved about whether a certain mask would be worn, gloves, etc. Some folks had equipment that needed cleaning afterward, others didn't. A lot of those kinds of differences, all of which were brought to the fore by Tyson in their original arguments against class certification. The plaintiffs, for their part, had experts who calculated the average time by a subset of observed employees taken to don and doff their equipment and to clean them. Another expert took those numbers and calculated the corresponding damages that would result if those average times were used. Even those experts, however, or the calculation expert, conceded that using the average figure would still leave some employees without reaching the 40-hour threshold. In other words, even using the averages, there would be some employees who would not be entitled to overtime, who would not have been injured by this alleged underpayment and failure to capture time. That could turn out to be critical. The district court certified a Rule 23b3 class and conditionally certified a FLISA collective action. Thereafter, Walmart v. Dukes came out from the Supreme Court, that opinion talking about the difficulties both under the commonality prong and otherwise for certifying claims where employment claims might involve a lot of individual differences. The district court on that motion for decertification denied it. And we see here the analysis morphing a little. The Judge Bennett, who originally certified the class, had talked about the fact that Tyson used a, quote, gang time system, which measured time based on when the first piece came past your station on the assembly line to when the last piece did. And in the original opinion, Judge Bennett really focused on that and said that that was the tie that binds the class together. But when we see it come back up in the district court on that motion for decertification, the analysis changes arguably a little bit. There, we see the following. In addition to the common legal question identified by Judge Bennett, which this court has interpreted not to be a challenge to the legality of the gang time system per se, the court goes on to say, well, there were a lot of other common things. You know, there was time spent donning, there were a lot of commonalities. Judge Bennett also noted, they say, numerous factual similarities among the employees paid on a gang time basis. Then there's a sentence that actually uses the phrase unlike Dukes twice in the same sentence and says we're not going to decertify these classes. Subsequent to that, there was a jury verdict for the class based on the expert's testimony from the averages, but notably not in the full amount requested, suggesting, or certainly Tyson has argued, suggesting that the jury was not completely buying the expert testimony, but that's all they had to work with, so they discounted it. So, case goes up to the Eighth Circuit, and the certification is affirmed, but we're going to see it morph a little bit again here in the Eighth Circuit. The Eighth Circuit finds no abuse of discretion in the case, in the certification, but arguably that holding is based on a little more FLISA-specific concern. We see here the Eighth Circuit says, quote, true, applying expert testimony to generate answers for individual overtime claims did require inference, but this inference was allowable under Anderson versus Mount Clemens Pottery, a Supreme Court case from 1946. Now we see, as I note there on the slide, that was an FLSA case which essentially shifted the burden to the employer and allowed a reasonable inference, quote, where the employer's records are inaccurate or inadequate and the employee cannot offer convincing substitutes. The employer cannot be heard to complain that the damages lack the exactness and precision of measurement that would be possible had he, meaning the employer, kept records in accordance with the requirements of the FLSA. Now, that 1946 case involved 7 individual plaintiffs and a union as plaintiffs, and the allegation was that the time clock being used by the employer was rounding to the nearest quarter hour, which was resulting in minutes being lost. The employer said, well, we don't know how many minutes were lost by our doing that, and the court said, well, some inferences can be made because you violated the FLSA record-keeping requirements in not having that information. So Tyson argues that's not quite applicable here because, Tyson would say, there was already a violation in the Anderson case, and then inferences were allowed to calculate damages, where Tyson says, look, here inferences are required even to find violations with respect to these folks, many of whom concededly are not going to be underpaid even if the averages are used. So we see this is set up in the Supreme Court in such a way that it could result in a a broad determination about due process issues in class certification, the use of averages, statistics, etc. Or we could see an opinion that comes down, as the Eighth Circuit did, in a relatively more narrow, employment-centric kind of way. Notably, Walmart has also filed, this has not been granted, Walmart has filed a petition for review, also an employment case, which resulted in a $150 million verdict against Walmart in a wage and hour case that came up through the Pennsylvania State Court pre-CAFA, before the Class Action Fairness Act. That case probably will go whichever way Tyson goes. So very significant cases from a class action perspective, but susceptible of decision on more of a FLISA or an employment basis. We'll just have to see what happens.
Thanks, Valerie. On the issue of class certification and class actions, there's one other issue that's percolating in the lower courts. Before we get to that, here's a reminder about CLE credit. For those of you who are listening in and would like to receive CLE credit for the webinar, you need to enter a confirmation code, and the confirmation code is AUTUMN. So please use the code AUTUMN for the sign-in sheet that you download from your viewing console. So back to the class action area. Tom Byrne, tell us a little bit about this ascertainability issue that's kicking around in the courts of appeal.
Well, you can never make a career out of trying to guess which cases the Supreme Court will take, especially in petitions that have not been filed, but we see a very raw and important circuit split developing in the class action area with respect to the implied requirement of ascertainability. The split, and the cases are on the screen, is developing quite boldly with the Mullins case from the Seventh Circuit, which took on the Third Circuit's Carrera case, which was the first real strong endorsement from a circuit court of the ascertainability requirement. It's spelled out in detail its implications. Mullins contradicts Carrera, critiques it, goes through it in some detail, and rejects it. So this is quite a split among the circuits here. Recently, the Second Circuit, just last week, in the Brecker case, though it involves the Republic of Argentina, actually was a class action involving some bonds, and the court, without citing Mullins, agreed with Carrera that ascertainability is a requirement. What's the split about? Well, the Carrera view of the world is that a class has to be sufficiently definite so that it is administratively feasible for the court to determine whether a particular individual is a member. So many hearings or elaborate inquiries about who's in the class are out of the question, and this requirement looks behind the class definition to determine whether or not the defendant has records, for example, that can be used to locate and identify class members. The other side of the argument has been that if a defendant doesn't keep good records, the defendant shouldn't be rewarded for that, but that argument hasn't found much traction in the Third Circuit, at least. The Mullins side of the argument, the Seventh Circuit opinion, states, yes, there is an ascertainability requirement, but it's only a requirement about the class definition. It's not looking behind that. The class has to be defined with objective criteria, and you can't have a fail-safe class or one that turns on a determination of the merits as to each class member. But that's it. The Seventh Circuit says that, and holds in Mullins, that other Rule 23 requirements actually cover the concerns that arise, that are identified in Carrera about identifying class members. So there will be further proceedings, probably in Mullins. I haven't seen yet if an in-bank petition has been filed, but sooner or later, probably this term, the court will have before it a cert petition or two dealing with the ascertainability issue, and it will be a hard one for the court to ignore given how clear the split is.
Thanks, Tom. We do have a little additional time wanted to mention a couple of other pending cases that the court's going to decide whether to grant cert on that should be of interest, a couple involving ERISA, for example. As Tom mentioned earlier, the court is going to hold its first conference of the term next week, and there are cert petition pendings in 2 additional ERISA cases. Both of these cases involve, in one way or the other, the scope of authority of plan administrators and other fiduciaries. These 2 cases are, one, there's the United Refining versus Cotillion case. There the issue is whether ERISA contains certain restrictions on the ability to amend an ERISA plan, and the issue there is whether those restrictions apply not only when the plan itself is actually, the language of the plan is changed, but whether those restrictions also apply when a plan administrator interprets the plan in a way that itself seems to be a departure from a prior interpretation. So that case raises an interesting issue of, to what extent a plan administrator's decisions applying plan terms are subject to being second-guessed by courts as being improper amendments of the plan itself. The other ERISA case that's where there's a cert petition currently pending is Sun Life versus Evans, and there the issue is where an administrator makes a decision and the decision is later deemed to be inappropriate, or the court disagrees with the decision. Does the administrator get to have a do-over, basically, and reconsider the claim and reconsider other issues that the administrator did not previously rule on, or whether, in the alternative, if the plan administrator is held by a court to have reached the wrong decision, does the court itself then go ahead and rule on the other issues as well, or whether that should go back to the plan administrator for a first decision. So again, 2 more ERISA cases that are on the docket with pending cert petitions, and we'll wait to see if the court grants review on either of those cases. We do have a little time left. We have 1 question pending. If anyone has any questions, please add them, and we'll try to address them in the time we have remaining. The 1 question we have pending, and I think this goes back to the issue early on from the discussion of the same-sex marriage cases from this term, and their rulings that same-sex marriage must be recognized in all states. And the question we have are, what are your thoughts on the ability of a church or other employer with anti-same-sex religious beliefs to request or insist that its group insurance coverage exclude same-sex spouses from spousal benefits? Thoughts on that? My first thought is it implicates a couple of issues that are, one of which is kicking around in the lower courts. That is, to what extent must there be a religious exemption granted to certain requirements under the Affordable Care Act, including contraceptive coverage? Most lower courts have ruled that the administration's religious accommodation exemption that they've come up with has been sufficient, although a court recently came out the other way and ruled that, I believe it was the Little Sisters of the Poor, that the current exemption was not enough of an accommodation and that their First Amendment rights were violated. That issue, the fact that there are now lower courts in disagreement, suggests that issue could be teed up to the Supreme Court eventually. In the same-sex marriage cases themselves this year, that issue did actually come up. To what extent do churches and other groups that oppose same-sex marriages, to what extent can they continue to express their views? This was actually at the end of the majority opinion. Justice Kennedy acknowledged that, and indeed wrote an assurance that churches and other religious groups that oppose same-sex marriage can continue to express their views, but there is a lot of thought that beyond mere expression of those views, that is, expressing doctrine, theology, preaching from the pulpit, and other writings, that it may be difficult, in particular, for for-profit groups to discriminate in any way against same-sex married couples. There's litigation involving the florist in Colorado and the bakery both businesses owned by people who profess religious views that they say do not permit them or to serve at same-sex marriage ceremonies. Those cases are in litigation. I think the other case that's implicated is the Hobby Lobby case from 2014, in which the court did say that that certain provisions of the Affordable Care Act that required contraception coverage may, in fact, have violated the Federal Religious Freedom Restoration Act as applied to certain very closely held for-profit businesses who had religious objections, strongly held religious objections to providing contraception. So you've got the holding in the same-sex marriages cases that suggest that fundamental rights are implicated there. You've got the Hobby Lobby decision upholding a challenge to contraception coverage. I think these issues there are certainly going to be actively litigated. I don't know if others on the panel have thoughts on those issues. I think that a key issue will be to what extent is the organization that would like to provide that kind of group coverage, to what extent is it, I think to the extent it's a nonprofit, an actual religious group, it's probably going to have a stronger claim. The Hobby Lobby case, for example, emphasized that this was a very closely held, it was a for-profit company, but closely held, and so the religious beliefs of the closely held owners were, I think, carried some weight.
Tom, I agree with all that. I would also not be surprised to see a distinction made or attempted between religiously recognized marriage and civil recognized marriage, which is less workable with respect to contraception and some related things, but I wouldn't be surprised to see arguments on those lines in this context.
Right, and I think the organization, if an organization wanted to go that route and try to insist on some type of coverage, I think it would be imperative on the organization at a minimum, in order to have any shot of winning the forthcoming discrimination challenges to that, they would have to show that those religious beliefs were, a core part of the business, and that this requirement, in the language of the Hobby Lobby case, that requiring that sort of coverage in their insurance would impose a substantial burden on their religious liberty. Again, fascinating issues, and no doubt those will be actively litigated in the very near future. We are at the end of our hour. Again, the CLE code for those who want CLE credit is autumn. And as a reminder, to receive CLE credit, please download the CLE sign-in sheet and evaluation and follow the instructions that are on there to submit it and receive CLE credit. We thank you all for joining us today, and if you have any further questions about today's topics, feel free to contact any of the speakers. Our next webinar in this series is scheduled for October 13th, also from 12 to 1 p.m. Eastern. Our October webinar will feature a discussion about recent and future technological developments in transportation, including autonomous vehicle technology, driverless cars, in-vehicle technology for monitoring driving habits, and how these technological initiatives will impact the insurance industry, in particular from underwriting and pricing, auto insurance, and claim handling issues. So we hope you will join us for our October webinar, and stay tuned for announcements of our future programs. Thank you.